I've attended some of the other PCRN webinars over the past few weeks, and I found them all to be, very helpful, very insightful, and they've set a very high bar, and hopefully this can follow that today. So the topic that I'm looking at is advanced care planning, in particular issues raised by the COVID-19 pandemic. And I'm sure, like many of you over the past few weeks, I've spent my time attending various webinars, reading newspaper coverage, and reading academic articles on COVID-19. And across these, there have been a small number of well-reported cases of poor advanced care planning or DNAR practice. In particular, there has been some especially egregious examples of poor advanced care planning and DNAR practice in the UK. And a key point to mention at the outset here is that COVID-19 does not provide a justification to move away from established principles and human rights. And what we saw in these examples of poor advanced care planning, particularly from the UK, was mainly a failure to adhere to those basic principles and human rights. And I think across this webinar, there's a number of kind of general takeaways that I hope you'll get from it. The first one, I suppose, is that advanced care planning is person-centered. It's something which needs to take place in a timely manner. It's about adherence to core principles which underpin decision-making and patient autonomy. And while these points may not be particularly, might not be a particular revelation, they are points which are fundamental to advanced care planning and cannot be abandoned at this point. So, if we just move on to the seminar outline on slide 3. So the seminar outline, I'll start off by mentioning issues in relation to advanced care planning during COVID-19, and I'll highlight some of the challenges. And what you'll see is that the challenges, I suppose, relate to issues around human resources, administrative burdens, issues of unease, and quite often the challenge here, or the issues, are not maybe legal issues, but instead, in order to deliver good advanced care planning, it's important to be aware of what those general principles are and how to incorporate them. The next element I look at then is the experience of advanced care planning. So this draws on quantitative and qualitative research, which I conducted last year along with a colleague of mine in the School of Law, Dr. Hope Davidson. This was IRC and AIIHPC funded research, and one of the questions we asked related to issues around advanced care planning, people's experience of advanced care planning, their familiarity with it, and their thoughts on engaging in advanced care planning. And it really, I suppose, demonstrates that it's often about communicating the basics with an individual and also getting a sense of what their knowledge is to ensure that appropriate advanced care planning is taking place. From that then, what I tend to do is I set out some of the general principles that are relevant to advanced care planning, starting off with dealing with some of the cases in relation to the presumption of capacity and the assessment of capacity, linking that through to the HSE National Consent Policy. I also speak about the legal framework for advanced healthcare directives and the legal framework for DNAR orders. In particular, in speaking about advanced healthcare directives and DNAR orders, I make specific reference to some of the case law from England and Wales. And the reason for doing that is because they've had a number of cases which have tended to illustrate some of the general principles which we should be aware of here. One point to mention at the outset is the Assisted Decision-Making Capacity Act of 2015. I will touch on that piece of legislation at times. It's a piece of legislation which has been enacted but not commenced, so it doesn't necessarily have full legal effect. One of the things that the 2015 Act deals with is the area of advanced healthcare directives. So there'll be a brief mention to it, but it's really important to emphasise that the fact that it hasn't been commenced at this point. And the point which I've noticed emerging over the last few months is that there's often kind of a tendency to act as if the legislation has been commenced. So what I'm going to focus on very much is the legal framework as it currently stands, rather than what it might look like in a year or two's time. At the very, very end, then I'll have there'll be some time for questions and answers if you want to go into any point in a little more detail. So looking at the next slide, advanced care planning during COVID-19. With this, what I wanted to consider was really what factors care planning particularly difficult during COVID-19. Some of these are general factors. They're not specifically, they're not specific to COVID-19, but they exist across the broad spectrum of advanced care planning. So, for instance, the first point there may be an unease at raising the issue of advanced care planning. So some of these factors are not just aimed at the health and social care professional, but they're factors which may stem from the individual themselves and what their concerns are. So there might be a general unease at discussing that particular issue or reluctance to engage in that type of discussion, for instance, and that can limit some of the discussions that might take place. Despite that unease, it's often necessary to address this at a relatively early stage or as early as possible, issues of advanced care planning. I know that there's been research conducted in the last year by the members of the International Observatory on End-of-Life Care in Lancaster University, where they looked at issues around advanced care planning and how to bring up or how to raise issues in relation to end-of-life care. And the general issue here really was, or the general point emerging was that the earlier that you can engage in these discussions, the better, because if they're left till a later point in a patient's disease trajectory, it results in the patient experiencing considerable distress when they're faced with, I suppose, a discussion which links very much with their own mortality. So these discussions have to take place at an early point in time. Saying that then, though, the next issue, obviously, the next points 2 and 3 are closely related. Obviously, there's been considerable pressures placed on human resources, but also an administrative burden that can arise under COVID-19. So it may be that there's insufficient time to engage in these discussions fully. The next point there is the administrative burden. So obviously there's an administrative burden also associated with the review of existing care plans, a point which occurred at the start of the COVID pandemic, where issues in relation to medication management, it was necessary to review certain care plans, to speak with patients, and that obviously was an additional burden which healthcare professionals were facing. Another issue that has arisen, obviously, is a lack of access to family members. Again, this is an issue which may affect the individual, where they may find it difficult to speak face-to-face, simply because of issues around maybe visitation if it's in a residential care setting. And that may be access to family members or friends, for instance. And again, this is also an issue which may be relevant for health and social care professionals in terms of engaging with family members. While a family member won't have the final say in relation to it, the views of a family member might often be canvassed. The final point here on this slide is concerns surrounding resource availability. And certainly this was a major issue at the start of the COVID pandemic, where there was concerns about the allocation of scarce resources. There was an article published early on in the pandemic in the Yale Law Journal, which resulted in considerable backlash. And there was an attempt to request or an attempt to push for its withdrawal from publication, because it dealt with these issues, or it looked at these issues around resource availability, and was arguing that not everyone is going to have access to these resources, and certain difficult decisions might have to be taken. This issue around resource availability as well has obviously created pressures and resulted in some examples of bad advanced care planning and do not attempt resuscitation orders, processes surrounding that, as demonstrated by the news stories on the next slide. So the next slide shows 2 images from The Guardian. So if we can just move forward one. So you have 2 examples here where you have one with the UK healthcare regulator branding resuscitation strategy as unacceptable, and another story relating to a Welsh surgery which had to apologise over do not resuscitate instructions. So these were examples of poor practice. In response to some of these poor practices, there was a joint statement put out which involved, I think, was the BNA, the GMC, and there was one other body, as far as I can remember, which spoke about DNAR practice and the way in which it was to be approached. The example of the Welsh surgery, again, it's an example where they adopted a general approach to do not attempt resuscitation orders rather than dealing with the individual patient as such. There was just a push for certain categories of patients to complete a DNAR. really without, I think, adequate consultation. So there was patients received a letter from this surgery, and it stated that completing a DNA CPR would have several benefits. The first of which it claimed was that your GP, and more importantly, your friends and family, would know not to call 999. And the second point it suggested was that scarce ambulance resources can be targeted to the young and fit who have a greater chance. So really a letter like that from the surgery was completely inappropriate, and certainly, as you'll see later on when we discuss DNA orders in England and Wales, cases like Tracy emphasise the importance of patient involvement, clear communication with the patient. So really, on a very simple level, this was a failure to adhere to basic principles of DNA or practice which had been established in the jurisdiction. Instead, and as I mentioned, I think 2 slides ago, what we should have seen here is really a person-centred, individualised approach being at the heart of advanced care planning. These types of decisions cannot be made on a group basis. The decision should obviously take place in good time. It shouldn't be a last-minute process, and it's unlikely to be a once-off process as well. Another point, obviously, is advanced care. Linked with that is advanced care plans will often obviously need to be revisited, updated at regular intervals. And in preparing this particular webinar, one of the points which I began thinking of is that as we're perhaps in a period between, or maybe in a slight lull in terms of the number of COVID cases that we have at present, that this might be a particularly good time to engage in and to promote active involvement with advanced care planning, so that these types of pressured decisions are not taken and that people have kind of, a greater time to discuss and ask questions related to their care. The next slide highlights some of the benefits of advanced care planning, and again, this is not specifically limited to COVID, but it's a general issue, a general points in relation to the benefits of advanced care planning, and benefits including relieving the burden placed on a patient's family. In this respect, patients or family members would have a record or an indication which can guide medical treatment. It tends to avoid conflict or can support, can lessen the risk of conflict between family members and relieves the moral distress that's placed on families. Families may often think that they're making the final decision in relation to a form of treatment or care. The reality, I suppose, is that while the family might be consulted, they shouldn't be making those types of decisions. Again, going back to fundamental principles of consent. The second point there is that it can protect the patient's right of autonomy. A good advanced care planning can enable the participation in the decision-making process, but really in order to achieve this, the necessary conversations have to take place at an appropriate time. So it really cannot be last minute. And the last point there, I suppose, is it can raise awareness about the types of treatment and care that might be available to the patient at a point in the future. And a broader benefit as well is that it might reduce anxiety, both for the individual, but also for their family as well, to know that these issues have been discussed and there's some clarity around them. However, the reality of engaging in these types of advanced care discussions is probably somewhat different, certainly outside of care settings. And we can see this on the next slide. So the next slide, the experience of advanced care planning. So over the next, I think it's about probably 3 or 4 slides, I've a data set out here which underlines the importance of discussing preferences for care and communicating basic concepts. The data set out is drawn from an Irish Research Council New Foundations project. This was completed last year. I was the lead researcher on it. You can see the URL link on the current slide if you do want full access to the report. It was a report undertaken with Age Action Ireland. The research project was shaped by 3 core objectives. The first of these was to explore the older person's understanding of autonomy in healthcare, familiarity with decision-making practices, and awareness of forthcoming decision-making supports. The second objective was to identify the priorities, concerns, and needs of the older person around this topic, namely healthcare decision-making. And the third objective which shaped the research was a desire to identify the shortcomings between the legal framework and subjective experience of research participants. So this is a point which I'm broadly interested in, where what we set out in the legal framework or what the ideal is within the legal framework, it might not always be what we actually see in practice or the way in which care is delivered. In this research, we had 283 responses in total. We asked questions relating to the standard of health, consent to medical treatment, and questions relating to advanced care planning. It's important to note that the cohort was well educated and relatively healthy. So what we do see here is that what we would have expected is that the figures in this particular research project are perhaps slightly more positive than what broader research might indicate. So on the current slide as well, you can see that the breakdown of responses by age, with quite a large number of respondents over the 80 plus category. This was one of the points which, if the research was to be run again, I'd change, because I think to recognise, and even at the outset, we knew that we were responding to a changing and ageing society. So it really should have been perhaps an 80 to 84, 85 to 90, 90 plus, to really get a broader or kind of a more detailed insight into the data afterwards. In relation to the questions on advanced care planning, one of the questions we asked was whether the respondents knew what an advanced healthcare directive is. Just over 60% of respondents did not know what an advanced healthcare directive is. A little over 17% were not sure, and 22% indicated that they knew what an advanced healthcare directive was. However, from some of the subsequent comments into quantitative research, and also into qualitative research that was conducted with a small number of focus groups, what seemed to emerge is that there was some element of confusion here. So some people thought they had an advanced healthcare directive, whereas what they actually had was a power of attorney instead. This next question was, have you completed an advanced healthcare directive? We knew this would be a relatively small number of people would have completed it. 88% of respondents had not completed an advanced healthcare directive, about 3% were not sure, and 8% had completed an advanced healthcare directive. Again, the above proviso continues to apply, and it would appear that several of these respondents may have completed a power of attorney instead of an advanced healthcare directive. The next question set out. Thanks very much, Clodagh. Was asking the respondents whether they had discussed their wishes for end-of-life care with any of the following people, and this was particularly surprising. So we set out a number of different options, including family member, general practitioner, public health nurse, solicitor, priest or rabbi, a home care, home health provider. We asked whether they had not discussed their wishes, and whether there was someone else maybe that they discussed with their wishes with, but were not listed on that the list we'd provided. People could have multiple responses, so it was possible that someone might have spoken with a family member and a GP, so it allowed for us to kind of get a broad sense of who people were engaging with. The majority of respondents, as you can see from the current slide, just under 55% had not discussed their wishes with anyone. And at a high level of people had spoken with a solicitor as opposed to a GP. One of the points that seemed to emerge from it is that when people thought about issues in relation to end-of-life care, what they seemed to think about was financial or estate planning, rather than necessarily thinking about their health care, hence the high number of people who'd spoken with a solicitor. Another point which did emerge when we kind of did a deeper dive into data was that there was a difference in the response rate between people who lived alone and people who lived with a partner or a spouse. About 50% of people who lived alone had not discussed their wishes with anyone. This is in contrast to about 65% of people who were living with a partner or spouse. So it seems if for people who are living alone, they might have taken that additional step to make sure that someone was aware of what their wishes were for the end of life care. Whereas for a person who's living with a partner or spouse, it was perhaps assumed that the other person would know what they wanted or would look after their wishes, and they didn't actually have that discussion. So that was really kind of a notable point. One point to bear in mind for the next slide is that low level of discussion with the GP at about 4%. So if we look at, move on here where we question 18, and we asked should the GP raise issues of advanced care planning with the person. A little over 50% of respondents replied yes. No response was much lower at 12%, while about 35% of respondents didn't actually know whether their GP should raise the issue of advanced care planning with them. Persons who had discussed their wishes for end-of-life care with someone were far more likely to want their GP to raise the issue of advanced care planning with them, in contrast to persons who did not have or had not had such discussions. There was also an opportunity for kind of open-ended responses near the end of this research, and the majority of comments related to issues around advanced healthcare directives, the provision of information, the support being provided, and also issues relating to patient involvement. And when we really look at those issues around information, support, patient involvement, these are all really essential elements of an individual exercising their autonomy. So if we look at the slide that's up at the moment, when we speak about autonomy here, we say autonomy is really about people having a say or control over their health care. We see autonomy recognised within the Constitution, recognised under Article 8 of the European Convention on Human Rights, and also recognised and protected in legislation. When we're dealing with this topic with students, either at an undergraduate or postgraduate level, and we're discussing autonomy, the starting point is normally a discussion of capacity. And this links in with an idea that Mary Donnelly would have spoken about previously, Professor Donnelly, a lecturer in UCC, where she would describe capacity as being a gatekeeper for autonomy, that if an individual is to make these decisions, to be involved in it, capacity is often the first hurdle in ensuring their involvement. And when we speak about capacity, again, I'll draw briefly on the 2015 Act here, that it's described as an ability to understand at the time that a decision is to be made, the nature and consequences of the decision to be made by him or her in the context of the available choices at the time. So we can move on to the next slide here. So what I want to set out is really some of the basic principles relating to capacity, issues around advanced healthcare directives and DNARs. Our starting point here is that there's a presumption of capacity. So if you're engaging in advanced care planning, you assume the individual has capacity. This is, however, a rebuttable presumption. We see the recognition of presumption of capacity, first off in a case of REC, an English case, but then we see a recognition of it in Ireland very, very clearly, and we'll see it in the next slides, in the case of Fitzpatrick and Kay from 2008, where that presumption of capacity is recognised. It's also recognised in the HSE National Consent Policy, where the extract on the current slide, that those who provide health and social care services must work on the presumption that every adult service user has the capacity to make decisions about their care and to decide whether to agree to or refuse an examination, investigation or treatment. I did mention that this presumption of capacity is a rebuttable presumption, and a capacity assessment will often take place where trigger exists, and this term trigger is the language that's used in the HSE National Consent Policy. Under this, it says that the possibility of incapacity and the need to assess capacity formally should only be considered if, having been given all appropriate help and support, a service user is unable to communicate a clear and consistent choice, or is obviously unable to understand and use the information and choices provided. There's a number of different approaches to the assessment or the assessment of capacity. So we've approaches such as the status approach, the outcome approach, and the functional approach. And it's really that the functional approach is what guides us in our assessment of capacity. It's an approach which is time and issue specific. So we see details of the functional approach to capacity on the next slide. So the functional approach assesses a person's ability to make a particular decision rather than focusing on a person's medical diagnosis, as a status approach might do. It's not a general decision about cognitive ability. It indicates that a person might be able to make some decisions and not others. In this respect, then, it may be seen as a hierarchy in the type of decisions which can be made. So this really depends on the seriousness and the consequences associated with a particular decision. So if something is relatively an inconsequential decision, relatively straightforward, we're not looking for a very, very high level of capacity there. Whereas if something is, I suppose, related to a much more serious issue, if it's related to life-preserving, life-sustaining treatment, then courts tend to demand a very, very high level of capacity, a very clear understanding of the situation if that decision is to be upheld. Another element with the functional approach is that it's not a single assessment of capacity. It does need to be revisited for other decisions, and revisited obviously if there's a trigger to suggest that that assessment does need to take place. The functional approach is also set out within the HSE National Consent Policy and the Irish Medical Council Guide to Professional Conduct. So if we can turn to one of the first cases here, the case of Fitzpatrick and Kay is set out on the current slide. So it's a case from 2008, came before the High Court. For our purposes, this is a case which demonstrates the presumption of capacity, and it also details issues relating to an assessment of capacity. The factors that it sets out in relation to the assessment of capacity are simplified and shortened to some degree in the HSE consent policy, and that's set out in about 2 slides' time. The background to this case is that it involved a 23-year-old foreign national. She had just given birth, suffered a hemorrhage resulting in a cardiovascular collapse. When she was admitted to the hospital, she had stated that she was a Roman Catholic. At this point, however, the medical team were informed that Kay would not accept blood for religious reasons. The medical team was concerned that she would die without a blood transfusion, and they called the master of the hospital. The master of the hospital spoke with the woman and had some doubts about her capacity to make the decision. This resulted in an application being made to the High Court for an emergency order, giving the hospital the authority to provide a blood transfusion to Miss Kay. This is a case which is often, one of the points that often comes up here, and it's an important point to clarify as well, is that there's often a reference to tomatoes and Coca-Cola in this particular case. So one of the suggestions, or one of the suggestions of why the individual lacked capacity here, or why there was some concern about her capacity, is that she had raised the possibility of being treated with Coca-Cola and tomatoes. When you read the particular case, it's clear that she wasn't suggesting that this was in any way an alternative to blood transfusion. It's sometimes portrayed in that way. Instead, the young woman suggested that people often received tomatoes with nutrients in them, and that this might allow her to recover over a period of time. Nonetheless, it would still perhaps demonstrate a failure to appreciate the seriousness of the circumstances she was facing, or the urgency of the decision that she had to be made. One point as well that I tend to emphasise in the undergraduate and postgraduate classes is the speed at which these decisions are made, and the fact that we can spend a long time afterwards dissecting the decision, but really the first contact with solicitors on the part of the hospital here took place at around 12 o'clock, and an ex parte order was made at 1:45. So you have a very, very short window in that first application being made, whereas we're in kind of a nicer position to sit back and to analyse what the court decided. In granting the order, a sedative was administered to the woman and a blood transfusion was commenced. After this, the hospital sought a declaration that it was entitled to apply to the court for the injunction, so really just making sure that they were on firm legal ground. The individual, in this case, Miss Kay, counterclaimed and argued that there had been a breach of her rights. The case would ultimately really turn on that assessment of capacity. And in that regard, Justice Lafay set out 6 principles which are still relevant for our approach to capacity. The first of these is set out in the next slide. So the first point here is that there's a presumption that an adult patient has the capacity, that's to say, the cognitive ability to make a decision. So our first point is we're saying there's a presumption. The second point here, so we're saying whether it's by reason of either a permanent cognitive impairment or a temporary factor. What we're concerned with here is whether the individual's cognitive ability has been impaired to the extent that he or she does not sufficiently understand the nature, the purpose, or the effect of the prop for the treatment and the consequences of accepting or rejecting it. So that's the second point where we're really concerned with the nature of the understanding. So if we can move on to the next slide, we'll see that the third point. The third point here drew on the three-stage approach which had been set out in an English case of REC. But what the court focused on here was whether the individual comprehended the information. So did the individual comprehend and retain the information? It doesn't matter, we're not looking for retaining the information for an indefinite period of time. We're looking for whether an individual can retain the information for a sufficient period to allow them to make a decision. The second element then is whether they believed the information, and the third element is whether they had weighed the treatment information. So were they able to consider the alternative choices, likely outcomes in making their decision. So these are the 3 points which stem from the decision in REC. The fourth point set out by Justice Lafay is that in terms of looking at the treatment information, what we're concerned with is the information which the clinician is under a duty to impart. So it doesn't have to be a broad range of information. It's simply the information which is relevant to this particular decision and which needs to be provided by the healthcare professional. Okay, moving on to the final 2 points with points 5 and 6. Point 5 can often be confusing, and certainly when students see this for the first time, there's often kind of a double take and it has to be read twice. Point 5 says that in assessing capacity, it's necessary to distinguish between a misunderstanding or misperception of the treatment information in the decision-making process on the one hand, and an irrational decision or decision made for irrational reasons on the other hand. The former may be evidence of lack of capacity, the latter is irrelevant to the assessment. So what the court is really concerned with here, and what we're concerned with in assessing capacity, is whether the individual has failed to understand what that basic information is. The second point in terms of making the irrational decision, that's really, I suppose, the individual has understood the information, but they've come to a decision which the vast majority of people might find, unwise, or they might kind of question how the individual has arrived at that decision. Whereas what we're really concerned with here about capacity is, has the individual failed at a very basic level to understand and take in that information? And obviously it can be difficult to distinguish the two, and it requires a degree of questioning to understand whether the individual has really kind of satisfied those other points in relation to capacity assessment. And the 6th point there is the assessment of capacity is with regard to the gravity of the decision, as we mentioned. If we're dealing with a very serious issue in relation to advanced care planning, we're looking for a very high standard of capacity to be demonstrated by the individual. The decision of the court was ultimately that the individual, Ms. K, did lack capacity, and that the hospital was entitled to seek the injunctions that were sought. The transfusion was not unlawful. It wasn't a breach of her constitutional rights. These 6 principles, then, we obviously see them in the presumption of capacity, and we see them set out in section 5.5 of the HSE National Consent Policy. So if we can go to the next slide. So again, you can see here issues of understanding the information, sufficient understanding of the principal benefits, the risks, all of this is said. So this is really kind of framing the principles that would have been set out in the decision of Fitzpatrick and Gay in slightly simpler terms. Okay. So we'll move on from the presumption of capacity and assessment of capacity to a discussion of advanced healthcare directives. And again, I think the key point here is going to be the discussion of the case law from England and Wales to provide some guidance on issues that can arise. A general outline of the section is on the current slide, so we're looking at what is an advanced healthcare directive. Presumably most people are aware of this, although obviously the research that's conducted would suggest the general population have very poor awareness of what an advanced healthcare directive is. We look at the current legal position in Ireland. We'll set out the 2015 Act, again not commenced, and we'll look at the legal position in England and Wales, and we'll discuss some issues relating to DNA orders. The origin of advanced healthcare directives linked back to this particular paper around 1969 by Louis Guttner. It's due process of euthanasia, the living will of proposal. So this is really kind of where we saw the first idea for an advanced healthcare directive being proposed. And it's a very simple, very straightforward paper advancing this idea of, well, people are living longer, but within what we've seen before, medical advances are maintaining people, and we really need to find a way of allowing individuals to perhaps make a statement or give an indication of what it is that they would want if they find themselves in this situation. There's obviously this coincided with other developments around the same time. You would have had the ad hoc Harvard Committee on Brain Death meeting around the late 1960s, similar committees taking place in Ireland and looking at these types of decisions about patients and the ending of life-sustaining or life-prolonging treatment. The next slide provides a definition of an advanced healthcare directive. This is drawn from the Irish Council for Bioethics. In their document from 2007, is it time for advanced healthcare directives? Here they define it as a statement made by a competent adult relating to the type and extent of medical treatment he or she would or would not want to undergo in the future, should he or she be unable to express consent or dissent at that time. The Irish Council for Bioethics recommended the introduction of advanced healthcare directives. This was linked with protecting individuals' rights to self-determination and related rights around integrity, privacy and dignity. The definition on the slide refers to consent or dissent. What it doesn't address is the circumstances in which a patient might request a particular form of treatment. We generally view, obviously, advanced healthcare directives as a way of limiting life-prolonging treatment. However, the 2015 Act does recognise that a person might make a request for a form of treatment. The general guidance here is that such a request would not have to be complied with if the treatment would not be in the best interests of the individual. So very much like other aspects of healthcare and care provision, you give care which you view to be in the individual's best interests. You cannot be kind of compelled to provide care which is not in the individual's best interests. The Act does suggest that if you veer away from what an individual requests, then that should be noted at the time and reasons given for why there was a failure to follow that particular request. The background in, I suppose, what exactly is the basis for advanced healthcare directives in Ireland, and this is in some respects a little bit shaky. We obviously don't have a firmly established legislative basis just yet. Instead, what we have to do is to look to case law. The next slide mentions a case of ward of court. A ward of court was really the first case where we saw an indirect reference to a possible role for advanced healthcare directives. The general idea being that it was a case which recognised a right to refuse treatment. And the idea was that if we recognise a contemporaneous right to refuse treatment, then it may be possible to recognise or to allow an individual to exercise their autonomy in such a way that would provide for a non-contemporaneous right of refusal, and obviously that would take the form of an advanced healthcare directive. One of the other cases that often you see referred to in relation to advanced healthcare directives is Fitzpatrick, and with Fitzpatrick this was due to a reference to a Canadian case which dealt with issues around advanced healthcare directives. However, it really wasn't until the case we see on the next slide, Governor of Ex-Prison. So in the case of Governor of Ex-Prison from 2005, the decision of Justice Mary Baker here involved the prisoner on a hunger strike who had been protesting the conditions of his detention, and the prison sought clarification on whether they would have to respect the individual's wishes. The High Court here held that a freely made and fully informed decision of a hunger striking prisoner to refuse food and medical intervention until death must be respected by prison authorities and the state. So this was our kind of clear indication that advanced decisions would be respected by courts in Ireland, and this is the position that obviously will prevail until the 2015 Act commences. Some details about the Act are on the next slide. The relevant section being Part 8, which deals with advanced healthcare directives. In particular, sections 82 to 93. It will require certain formalities to be complied with, and in particular, obviously, validity and applicability of the directive have to be satisfied. It's this issue of validity and applicability which has been at issue in several of the decisions in England and Wales. And I think it's just about 3 cases I want to briefly, very quickly run through here. The first is Re-E. The case of Re-E is perhaps more relevant to a legal professional. Again, it deals with issues of validity. The individual in this case was a 32-year-old woman suffering from anorexia. She had other chronic health problems, including alcohol dependence. At the time, she was severely malnourished, was refusing to eat, and was receiving only palliative care. She had made an advance care directive indicating a desire to refuse treatment. She was aware that the diagnosis of anorexia might mean that there was a question about her capacity. She essentially went back, raised her body weight, and made another advanced healthcare directive with the idea of demonstrating her capacity and how serious she was about this refusal. And nonetheless, the local authority brought an application that artificial nutrition could be administered to the individual and treatment could be provided. And the issue here was that there hadn't been a contemporaneous assessment of capacity at the time that she had actually drafted that second advanced healthcare directive, and that was seen as a major issue. There had been some conflicting opinion about some conflicting medical opinion given in this case about whether she had capacity or did not have capacity. But I suppose what we see here is that if you think an individual is going to make an advanced healthcare directive, it may be wise to take detailed notes about the individual's capacity at the time, even if the solicitor involved is not undertaking a capacity assessment. 2 other cases to briefly mention, HE and case of Cumbria. On the next slide. The case of HE here, the issue here is that if an individual has an advanced healthcare directive, it is advisable to pay close attention to whether there has been a material change in circumstances which would suggest that the advanced healthcare directive should no longer apply, even if the individual has not maybe actively taken steps to withdraw it. So for instance, in HE, the individual had drafted an advanced healthcare directive while she was practicing as a Jehovah's Witness. She reverted to her original Muslim faith, had not taken steps to withdraw the advanced healthcare directive, but the opinion of the court here was that that change of religion was sufficient, that even though she hadn't perhaps officially revoked the advanced directive, that it hadn't survived some material change in the circumstances. The other case here, case of NHS in Cumbria, the point here in this case really is that you shouldn't rely on second-hand knowledge of an advanced healthcare directive. If you're informed that an individual or a patient has an advanced healthcare directive, then you should seek access to that original document. The key point in this case is that it's rarely, if ever, going to be sufficient to summarize an advanced decision in a telephone conversation. You have to have access to that original document in order to determine what care is to be provided. Okay? So they're kind of the key points coming out in relation to advanced healthcare directives. And the last thing I want to discuss is do not attempt resuscitation orders. So we don't have legislation governing DNA or orders in this jurisdiction. We do, however, have the HSE National Consent Policy, which sets out principles in the next slide. And we did have a case in relation to DNA or orders in the form of HSE and JM from 2017. However, it really, I think, told us very little about how these orders should be applied or really interpreted. And in that respect, I think, again, we've looked at the decisions in England and Wales. So we see on the current slide, we've the HSE National Consent Policy. This sets out general principles to be applied in relation to DNA or orders. Again, these are decisions it sets out which are to be made on the basis of an individual assessment, not to be made based on age, disability, subjective views of healthcare professionals regarding an individual's quality of life. Okay? So again, you'll be able to consult the consent policy in your own time. The case in Ireland on DNA or orders is the case of HSE and JM. It involved an individual who was 36 years old, was diagnosed as being in a minimally conscious state. So it's one of our first proper minimally conscious state decisions in the jurisdiction. The individual's parents would not consent, and it resulted in the applicant, in this case the hospital authorities, seeking the of the court that in the event of the individual's clinical deterioration, that they might withhold a range of different treatments. The court essentially interpreted this really as an issue around DNAR orders. And in determining the test to be applied, the case drew on the approach taken in ward of court and English decisions in relation to NCS. Again, really, I suppose, framing the issue around the best interests of the patient and determining whether it was appropriate for the DNA or order to be applied in this instance. It doesn't substantially advance the legal framework for DNA or orders in this jurisdiction, but at a minimum, it does indicate judicial approval for their use in practice. So the last case is then, or the very last case to discuss, is the case of Tracy in Cambridge. So the case of Tracy in Cambridge is a really important case in relation to do not attempt resuscitation orders. While it's a case from England and Wales, the principles established in it should really, I think, should be applied in this jurisdiction as well. The individual in this case, Janet Tracy, was a 63-year-old woman. She had metastatic lung cancer with prognosis of 9 months. At that point, she was involved in a road traffic accident and was made the subject of a DNA CPR order shortly after her admission to the hospital. The DNAR order was not discussed with Mrs. Tracy and was removed after her family became aware of it and objected to it. Subsequently, and after discussions with family, a second DNA CPR order was imposed, and Mrs. Tracy subsequently died without attempted CPR. One of the, an English barrister, Alex Rockeen, who specialises in the area of mental capacity law, suggested that this case of Tracy really illustrates two diverse approaches. The first decision around DNA CPR orders was really a poor, kind of a real failure in relation to communication, whereas the second DNA CPR really was kind of a much better approach in communication and speaking with the individual, engaging wishes, and it was really kind of a very clear split between those two orders. In relation to that first order, the family argued that this had amounted to a violation of her Article 8 rights, again linked with right to privacy. And the court here stated that since a DNA CPR decision is one which will potentially deprive the patient of life-saving treatment, there should be a presumption in favour of patient involvement. There would need to be convincing reasons not to involve the patient. The court went on to state that it's inappropriate and therefore not a requirement of Article 8, again about the right of autonomy, to involve the patient in the process if the clinician considers that to do so is likely to cause her to suffer physical or psychological harm. If, however, the clinician forms the view that the patient will not suffer harm if she is consulted, the fact that she may find the topic distressing is unlikely to make it inappropriate to involve her. So a general principle that we see across other issues around autonomy is that it really, especially around therapeutic privilege, is that it has to be really a very, very high standard of distress that the individual would experience in order to justify excluding them from the decision-making process. Okay, so there are some of the key points from Tracy. There was a further decision after Tracy, a case of Winspear, which was involved an individual who lacked capacity. Their family indicated that they wanted to be involved in the decision-making process. And in that case, again, the court recognised that where an individual said that they were essentially available to discuss at all hours, then the healthcare professionals involved should at least have taken account of their views and involved them. Again, it goes back to issues around Article 8 of the ECHR. So the very last slide, just a summary of some of the main points. So key points here really being that what we see is that a person-centered individualized approach should be at the heart of advanced care planning. The patient should be involved or has to be involved in the advanced care planning as much as possible. Decisions cannot be taken on a group basis as occurred in England and Wales. Ideally, the ACP should take place in good time. It shouldn't be a last-minute process. It's unlikely to be a once-off process. It might require multiple consultations. And in general, we'll see, I suppose, that there's often a need to revisit and update both advanced care plans at a general level, but also maybe advanced healthcare directives as well, depending on any changes in circumstances.